Welcome to the Bureau of Land Management online geothermal training program. This is the Geothermal Industry Training module. This training program was developed by the National Renewable Energy Laboratory, or NREL, for the Bureau of Land Management, or BLM. This training program is designed to provide industry with information about key oversight responsibilities related to geothermal operations in federal land. This is the Industry Training module. This module describes the geothermal lifecycle operations and procedures to follow on federal land, and operator responsibilities during each stage. Upon completion of this module, you will understand how a geothermal project is managed on public lands. Become familiar with the geothermal leasing and lifecycle of operations. Know the different geothermal lease types and the terms, requirements, bonding, and costs associated with BLM leases. Integrate BLM's role in parcel review into the larger leasing process. Learn processes for getting required permits for drilling and utilization of plant. Understand what production verification is and what is required of BLM related to production verification. Become familiar with the components of a complete inspection, identify typical violations, and understand the corresponding corrective actions. BLM authority to regulate geothermal operations on federal lands is established by the Geothermal Steam Act of 1970, 30 U.S.C. 1001 and what follows, as amended by the Federal Land Policy and Management Act of 1976, the Energy Policy Act of 2005, and others. BLM carries out this authority through its implementation of 43 CFR Part 3200. Leasing regulations are codified in Subpart 3200. Regulations for geothermal exploration operations are codified in Subparts 3250. Geothermal drilling operations regulations are codified in Subpart 3260. Sundry-related regulations are related to Subparts 3260. Utilization operations-related regulations are codified in Subpart 3270. Inspections, enforcement, and non-compliance-related regulations are codified in Subparts 3250, 3260, and 3270. Unitization regulations are codified in Subpart 3280. For projects on U.S. federal lands, BLM has oversight responsibilities throughout each of the phases of the life cycle of geothermal operations. During each phase, operators submit proposed actions and plans for BLM review and approval. BLM review also includes environmental analysis as required by the NEPA, among others. BLM review and permitting of exploration usually happens first in the geothermal life cycle. Review and leasing of nominated parcels occurs next, prior to any resource confirmation and site development activities. Note that exploration may occur both before and after leasing, and often continues as the site develops. After leasing, the drilling phase may commence and continues with the utilization phase. Bonding also occurs during the exploration, drilling, and utilization phases, with specific bonding requirements for each. Bonds are only released after final reclamation phase activities are complete, which includes well abandonment and facilities decommissioning activities for the later phases. BLM also conducts inspections throughout all of these phases and may issue enforcement actions if needed. Public lands can be nominated for lease sales by a qualified company or private individual. When compatible parcels are nominated, BLM holds a lease sale at least every 2 years. There are 3 types of leases: competitive, non-competitive, and direct use. Leasing-related costs include bonus bids, fees, rentals, royalties, and bonds. Lease parcel nomination review is composed of 4 parts. In Part A, parcel nominations are typically received by the state office, and a land law examiner parcels the land. These parcels are then sent to the relevant BLM personnel with geothermal responsibilities at one or more field offices. These personnel are then tasked with convening an interdisciplinary team, also called ID team, tasked with reviewing the parcels. In Part B, an ID team is assembled, and the team begins to substantively review the parcels. This specialist review might include field or desk review of parcels. If resources would potentially be affected by future development, the specialist must identify possible mitigation measures. In Part C, if resources may be affected, BLM staff can add lease stipulations to mitigate those impacts. The ID team must then review all the stipulations and identify whether there are residual impacts that are not addressed. The ID team then reviews environmental analyses and identifies potential lease stipulations that can mitigate these impacts. Finally, in Part D, the ID team compiles all lease stipulations by parcel. The authorized officer reviews and approves the stipulation list and submits the parcels to the state office. The state office reviews the list prior to the lease sale. After review and determination of the final leasing stipulations, the ID team provides the stipulations package to BLM state office adjudication staff, who then post the sales notice with the parcel list and associated stipulations for each. The public is given an opportunity to comment on or protest the parcel nominations and the environmental assessments, or EAs, and or determinations of NEPA adequacy, or DNAs, from the reviews. Often, this comment period lasts 15 to 30 days. Afterward, BLM reviews the comments and addresses them as needed. Then, at least 45 days prior to the planned lease sale, BLM posts the Notice of Competitive Lease Sale, also known as the sale notice. This notice includes the time, date, and place of the sale, the sale format and procedures, a listing of the parcels and parcel blocks available for sale, and the final lease stipulations for each parcel. The lease sale itself operates as a competitive auction. Since 2017, the auctions have taken place online, currently at energynet.com. Each parcel is allotted a sequential 1-hour bidding time so that bidders know the results of their previous bids before making final bids on subsequent parcels. Bids at the auction, also called bonus bids, start at $2 per acre and increase by at least $1 per acre. The winning bidder is required to pay a portion of the lease sale price by the end of the auction day to claim the lease, namely, at least 20% of the bonus bid amount, advanced payment of the first year's rental cost, or $2 per acre, and the fixed administrative filing fee, currently $170. The winner is also required to pay the remainder of the bonus bid amount within 15 days of the auction. Failure to pay any of these costs by their respective deadlines can result in revocation of the lease by BLM. There are two other pathways to acquire a geothermal lease: non-competitive and direct use leases. The processes for obtaining these types of leases are similar. Non-competitive leases for geothermal energy production are available for any parcels that were offered at a competitive lease sale that did not receive competitive bids during the sale. First, the parcels are offered at a day after sale, in which all offers for non-competitive leasing are considered to happen simultaneously. Any parcel receiving multiple offers is then issued by draw or lottery. Parcels not receiving offers during the day after sale are available for non-competitive leasing for a 2-year period following the sale on a first-come, first-served basis. Because the parcels have already gone through BLM review as part of the lease sale, an interested party is only required to submit the required form, processing fee, and advanced rental of $1 per acre to the BLM in order to obtain the lease. Direct use leases for heat applications are also available on a non-competitive basis if the lands in question have been determined to be open for leasing and deemed appropriate for exclusive direct use. That is, the resource at that location is better suited for heat applications other than geothermal power production. After receiving the leasing request, BLM posts a notice of the lands proposed for direct use for a 90-day public comment period. If the lands are not nominated for a future lease sale during this period and there is no other competitive interest for the resource, the direct use lease is then issued. While the regulations do provide for a competitive sale process if a direct use lease is nominated during this period, no existing direct use lease has been issued competitively. An operator is required to post either a corporate surety or personal bond before any exploration, drilling, or utilization operations begin. Bonding requirements can be found at 43 CFR Section 3200.4 and 43 CFR 3214. BLM's regulations set minimum bond amounts for each proposed activity, but BLM also has the discretion to increase the required bond coverage if deemed necessary. For exploration and drilling bonds, the operator has the option to post a bond for only that individual operation, a larger bond to cover all of their operations in a single state, or an even larger bond to cover all of their operations nationwide. However, a bond for a state license for an electrical generation facility must be posted on a site-by-site basis, as the costs of reclamation of power plant sites is significantly larger than that for individual wells and pads. The financial institution that holds these bonds will release them after BLM determines that all permit and lease obligations at a site have been met, including payment of rentals and royalties and adequate reclamation of the site. Additional details on bonding procedures can be found in 43 CFR sections 3214 and 3215. We will now shift discussion to exploration permitting and the BLM review process. Geothermal exploration under 43 CFR 3250 includes any activity related to the search for evidence of geothermal resources, where an operator is physically present on the land and their activities may cause damage to those lands. Geothermal exploration operations may include, but are not limited to, geothermal operations, drilling temperature gradient wells or TGWs, drilling holes for seismic charges, core hole and other drilling, and related construction of roads and trails, along with overland travel by vehicles on public land. Note that by definition, exploration operations permitted under the 3250 regulations exclude drilling or using any wells to test, produce, or utilize the geothermal reservoir or resource. Geothermal exploration requires a permit issued by BLM under an approved Notice of Intent to Conduct Geothermal Resource Exploration Operations, or NOI. The applicant submits the NOI via BLM Form 3200-9. The NOI submission must include the exploration plans and procedures for operations, TGW drilling plan information if applicable, evidence of bond coverage, which we'll discuss momentarily, estimated surface disturbance, usually in acres, environmental protection measures, and surface reclamation methods. After submission, BLM screens the NOI for any planned or expected disturbances and may expedite NOI approval and NEPA reviews if the proposed exploration activities qualify for a categorical exclusion, or CX. By using a CX, BLM reduces the time and costs associated with new NEPA analysis. However, if there are potentially significant impacts from the proposed exploration, then additional NEPA reviews and analysis are required. Note that BLM may suggest changes to exploration plans in order to qualify for a CX for NOI approval. During the NOI screening, if BLM determines that the proposed activities normally lead to minimal disturbance of lands, resources, or improvements, BLM may deem these activities as casual use. If BLM determines that the activities are casual use, no exploration permit is required, nor are any further reviews or approvals of the NOI. In this case, BLM then notifies the applicant that their exploration activities are casual use and that their NOI does not need approval. Even so, BLM may still require notification from applicants about their planned casual use activities, though the method for doing so may differ by BLM field office. Examples of casual use activities may include collecting geochemical, rock, soil, or mineral specimens using hand tools, water sampling, use of battery-operated devices for mineral detection, such as metal detectors, motorized vehicle use, including for off-road travel, if allowed by BLM land use plans for that area, and other minor surface disturbances of less than about 1 square meter. Exploration operations do not require geothermal lease on the surface areas proposed for study. This means that applicants may propose exploration on leased or unleased land, and proposals often include a combination of both leased areas and nearby adjacent unleased land. However, if the proposed lands are unleased, BLM review must first confirm that the lands are open for geothermal exploration. Lands that are not open for geothermal operations may include wilderness and national conservation areas, along with other areas of critical environmental concern. Additionally, applicants may request to perform exploration on lands for which they are not the leaseholder, that is, on lands leased to a different operator. BLM may approve these exploration activities so long as they do not interfere with or endanger the other operations or other authorized uses. This is allowed because neither a lease nor an exploration permit grant exclusive rights for surface activities. Exploration is also not limited to geothermal leases, but may be proposed on other types of mineral interests as well. If exploration occurs on lands managed by another federal agency, such as the U.S. Forest Service, the agency responsible for review and approval depends on the leasing status of the proposed lands. First, if the lands are leased and the applicant is the leaseholder, then BLM reviews and approves the NOI and exploration permit in consultation with the other agency. Otherwise, if the lands are unleased or the applicant is not the leaseholder, then the other agency is responsible for review and approval. Note that BLM or other agencies will not issue an exploration permit until sufficient bond coverage has been posted. An applicant must submit an operations plan, which applies to the design and details of surface operations associated with development of geothermal leases. A GDP application, or BLM Form 3260-2, for each well to be drilled. GDPs may be submitted simultaneously or after the operations plan. The drilling program, which describes all the operational aspects of a proposal to drill, complete, and test a well, including expected characteristics of freshwater zones, anticipated reservoir characteristics, blowout prevention equipment or BOPE, and a risk management plan in areas with known hazards, such as the presence of hydrogen sulfide or volcanic activity. Finally, an adequate bond must be in place prior to starting any operation. An operations plan includes all the designs and details of surface operations associated with development of a geothermal lease, including well drilling. BLM conducts a NEPA review for each operations plan, which generally involves an environmental assessment, or EA. As part of the NEPA review process, the BLM ID team reviews the operations plan for compliance with lease terms, conditions, and stipulations, and to confirm that applicant proposed environmental protection measures align with the mitigation hierarchy and meet applicable regulations. An applicant may submit the GDP applications with the drilling program and operations plan together or separately. Approval of a package authorizes surface activities and the drilling and testing of the well. If the operations plan is submitted separately, a sundry notice is required for surface disturbance. A GDP is BLM written permission to drill for and test federal geothermal resources. The official GDP application is submitted via BLM Form 3260-2 and is available online. BLM typically receives GDP applications for the following types of work: drilling a new well for exploration or production, re-drilling, deepening, and directional drilling for new legs and additional bottom hole locations. GDPs apply to production, injection, and observation wells. GDPs do not apply to temperature gradient wells, production facilities, or pipelines. There are three types of reviews in the GDP process: surface reviews, downhole review, and environmental review. Review timelines will vary, and reviews may take multiple months based on the complexity of the proposal, whether another surface management agency is involved, and the degree of alignment with existing NEPA review. The degree of environmental analysis required under NEPA for a GDP application depends on the extent of existing analysis. If the proposed action is covered by an existing NEPA, such as from an exploration or utilization plan, the authorized officer can sign the GDP. If the proposed action is for an action covered but not specifically authorized by an existing NEPA, the GDP is reviewed for alignment with the NEPA. If appropriate, the authorized officer can issue a determination of NEPA adequacy, or DNA. If the proposed action is not covered by an existing NEPA, a new NEPA is required. An applicant may submit the GDP application with drilling program and operations plan together or separately. Approval of a package authorizes surface activities and the drilling and testing of the well. If the operations plan is submitted separately, a sundry notice is required for surface disturbance. The following are some example drilling operations that require sundry notices: conducting a mechanical integrity test, or MIT, conducting a pressure temperature spinner, or PTS survey, changing the type of well, a change in the drilling plan, and abandoning a well, downhole plugging and surface reclamation. There are 4 general categories of sundry notices. The first is a notification sundry. This sundry simply notifies BLM that an action has been or is scheduled for completion. For example, operators submit a notification sundry for the date and time of well spudding, that is, when drilling starts on a new well, or of first production from an existing well. The next type is a notice of proposed action. This sundry requires BLM approval for a proposed new activity. For example, this type of sundry may be submitted when an operator seeks to deepen an existing well, change a well type, abandon a well, or perform well integrity tests or other surveys. Next, a subsequent report sundry provides documentation to BLM of work that has been completed. This work often includes actions that were requested via a notice of proposed action. For example, an operator may request to abandon a well via a notice of proposed action and then later provide the details of the completed work via a subsequent report sundry. The last type is a final reclamation sundry. This notifies BLM that final reclamation at a well location has been completed in accordance with previous approvals. The BLM must complete a final surface inspection of the site to confirm the reclamation meets the required standards before approving the sundry notice. Note that for well abandonment and reclamation, the final reclamation sundry focuses on the surface, while the subsequent report sundry details the work within the well bore. At a high level, a utilization plan must describe the proposed facilities, anticipated impacts, and proposed mitigation measures. For proposed plants sited on federal land, the proponent must also obtain a completed and approved site license and facility construction permit prior to beginning construction. The facility operator must obtain a site license approved by BLM to be able to start building or testing a utilization facility on public lands leased for geothermal resources. A site license is not required for plants proposed on private land, split estate where the surface is privately owned, or on unleased federal lands. The facility operator must obtain a facility construction permit approved by BLM before building or testing a utilization facility. If the construction permit is not submitted as part of a package with the utilization plan and site license, it must be submitted via a sundry notice and approved prior to construction. Details on site licenses and construction permits are located in 43 CFR sections 3273 and 3274. The facility operator must have a commercial use permit approved by BLM before beginning commercial operations from a federal lease, federal unit, or a utilization facility. BLM will check the commercial use permit application for technical adequacy and will ensure that meters meet the accuracy standards. The level of environmental review required under NEPA for a utilization plan depends on the scope of the project. See the BLM NEPA handbook for detailed requirements. Typically, utilization plans require an EA, though large or complex projects may prompt an environmental impact study, or EIS. If a separate federal surface management agency is involved, such as the U.S. Forest Service, the NEPA review is conducted with BLM as the lead agency. A joint NEPA process is desirable, but may not be efficient in all cases. BLM makes final decision on conditions of approvals, or COAs, in consultation with the Surface Management Agency. Ancillary and off-lease activities are approved by the Surface Management Agency. BLM and U.S. Forest Service responsibilities are identified via a nationwide Memorandum of Understanding, or MOU. Project-specific MOUs may also be utilized. BLM's production verification responsibilities include identifying sales point meters in geothermal facilities, reading, inspecting, and witnessing the calibration, when necessary, of sales point meters, whether on lease or off lease, ensuring that the proper federal shares of land area are being used in calculations through a review of the case file and unit agreement Exhibits A and B, and reviewing and verifying operator monthly reports to determine sales quantity reported to Office of Natural Resource Revenue, or HONOR, and to ensure consistency and accuracy. BLM should require the following from the operator: a monthly production reporting document, including the monthly report of geothermal operations and the monthly facility report, Minerals Management Service Form 2014 or Honor Form 2014, and a utility invoice. Through monthly inspections, BLM should acquire meter readings using Form 3260-16 for electronic meters and analog sales meters, and other forms for the geysers or analog flow meters. Though it is not required for BLM to collect all these documents or data to perform production verification, missing data make the process more difficult. The reclamation process involves restoring the original landform or creating a landform that approximates and blends in with the surrounding landform. 4 different reclamation processes may apply to an operator. First, the operator should submit a reclamation plan as a part of the operations plan to allow BLM to assess the environmental impacts of operations. Next, for well abandonments, the principal operator or lessee must send BLM a sundry notice documenting the plugging and abandonment program and get approval before starting to abandon any well. For facility decommissioning, reclamation plans are also included in the utilization plan and describe how the operator will abandon utilization facilities and restore the site. However, the principal operator or lessee may also file a request with BLM for a variance for the approved utilization operations from the requirements of Section 3200.4. Finally, after reclamation activities are complete, the principal operator or lessee can request termination of the period of liability from the BLM state office holding the bond. For well abandonment, the operator must send BLM a sundry notice documenting the plugging and abandonment program and get approval before starting to abandon any well. This sundry notice should include all the information required in the well completion report, a detailed description of the proposed work, including type, depth, length, and interval of plugs, methods you will use to verify the plugs, weight and viscosity of mud that you will use in the uncemented portions, perforating or removing casing, and restoring the surface, and any other information that BLM may require. For facility decommissioning, the operator must restore any disturbed surface and remove all structures when they are no longer needed for facility construction or operation. This includes the utilization facility if the operator cannot operate the facility and is not diligent in efforts to return the facility to operation. If the well and associated facilities are covered by an individual lease bond, the period of liability on that bond can be terminated once the final abandonment has been approved. If the well is covered by a statewide or nationwide bond, termination of the period of liability of these bonds is not approved until final abandonment of all activities conducted under the bond has been approved. The operator may request termination of the bond upon completion of reclamation. If there is a change of operator for the geothermal operations, the previous operator may request a release of their bonds only after the new operator has supplied an acceptable bond to BLM. For facilities located on federal land where a site license was required, BLM will release the bond after the operator requests that it be released, and BLM determines that the operator has removed the utilization facility and all associated equipment, reclaimed the land, and met all the requirements of Section 3200.4. Finally, BLM may collect against the operator's bond if the operator does not properly or in a timely manner plug and abandon a well, reclaim the lease area, pay outstanding royalties, or pay assessed royalties to compensate for drainage. BLM has the authority to conduct inspections at any time and must conduct inspections during exploration, drilling, and utilization. If issues are noted during inspections, corrections start with operator contact and issuance of a verbal warning by BLM inspection staff as an email or letter. If the issue is not correct within the specified time frame, the authorized officer may then issue a written incident of noncompliance, or INC. Operators must comply with BLM requirements, warnings, and orders. The BLM has the authority to shut down operations and cancel leases, and may collect against a bond if the operator is not in compliance or if the violation is a direct threat to safety of protected resources. BLM conducts inspections for protection of environment, human safety, and conservation of resources. The main issues for surface inspections can be grouped in 2 categories: general site inspection and well inspection. General site inspection includes, but is not limited to, pits, ponds, and water, pipeline or utility line, roads, equipment storage, hazardous materials, hydrogen sulfide warning signs and safety equipment, wildlife, vegetation and weeds, and erosion. Well inspections include the well sign, fence, equipment, fluid compositions, steam disposition, temperature, pressure, and flow rate, as well as hydrogen sulfide readings and meter calibrations. To summarize, here are some key takeaways from this training. Geothermal leases for energy production may be issued through competitive lease sales, or subsequently in a non-competitive manner if parcels are unsold. Leases for direct use or heat applications are generally issued non-competitively. A geothermal drilling permit is required prior to drilling each well that comes in direct contact with a geothermal resource. Sundry notices are one of the key pathways through which operators interact with BLM during geothermal operations. NEPA reviews are conducted during exploration, drilling, and utilization stages to assess environmental impacts throughout the geothermal lifecycle. A proponent or operator must submit a utilization plan to BLM for review and approval prior to building or testing utilization facility. BLM requires production verification, including monthly reports and utility invoices from the power plant operators. The operator is responsible for all reclamation activities to restore any disturbed surface and remove any structures when they are no longer needed for operations. Inspections are conducted by BLM personnel to ensure operator compliance with safety, environmental protection, and other regulations. This slide includes resources that may be useful for industry, including links to environmental planning and geothermal databases, related guidebooks, handbooks, and other reference documents, as well as other specific information referenced in this training. This concludes the Geothermal Industry Training module.